Be vitiated.
Without objection.
And, Mr. President, I had a number of amendments that I was just wanting to discuss, and thus the chairman is planning to.
Mr. President, yeah, it'd be fine if you could discuss the amendments, though, without attempting to offer any amendments.
No, it's not my intention. I just wanted to get a chance to talk about some of these amendments.
I appreciate that. If I could ask my friend about how long you figure that you...
Well, until you're ready to talk.
Hey, that sounds good.
All right. Thank you, Mr. Chairman. There are a number of amendments that I think will not probably come up, but they should have. We talked about this some time ago. The Federal Aviation Administration has come up with a change for their sub-S non-scheduled carriers that is going to make them comply with certain of the wage or the crew rest requirements. Here's the problem that we have. About 95% of the passengers that go in, this is our troops, go into Afghanistan today are carried by non-scheduled airlines as opposed to military, and about 40% of the cargo that's going in. Now, the problem we have is with the 15-hour restriction on crew rest, they're unable to bring them in, leave them there, and then go back to their point of origin someplace in Germany without exceeding that 15-hour limitation. And the only choice they'd have would be to leave them in Afghanistan, which they can't do because that's a war zone. So it's I want to have a way of working this thing out so that we can we want to pursue this because the carriers understand what the problem is, and these are the non-scheduled carriers. So it's something that I think is very significant, and we need to be addressing it. Another issue is JIDO is the group that is the Joint Improvised Explosive Device Defeat Organization. They've done great jobs in their technology and stopping the various technologies over there, the IEDs that have been killing and causing damage to our troops and to our allies. And the problem that we have is it is set up just for the Iraq and Afghanistan. Now, when everything is through in Iraq and Afghanistan, that might put them in a position where they would cease to exist. And yet the technology and what they're doing right now is useful here in the United States, even though it's not designed by the legislature to do that. This is something that can be, I believe, can be corrected. Another area that needs to be addressed, and I've got some ideas, and this is one I would like to get in the queue. It is not pending at this time, so there's a little bit of a problem there, but it might be something that could be addressed in conference, and that is the military bases should be able to benefit from production of domestic energy and resources on those bases. In the case of McAllister Depot, they could vertically go and horizontally drill and come out with really some pretty good royalties that would otherwise go to the general fund or go to the state of Oklahoma. It's kind of divided in that way. Well, the problem with this is there is a cost that's incurred by the military operation, and we would need to have something that is going to allow them to receive the benefits of the production that takes place under the military installations through horizontal drilling. I think everyone is for doing this, but the problem is it could be scored in that if you took all of the existing production, then that'd be money that would not otherwise go to to our general fund. So what I would propose is to have this in the form of an amendment and then change it to say any operation that is from this point forward, that money, those royalties could go back to the military base. Because what we all agree on is we don't want our bases to have to foot the bill for these things that are taking place. I had an amendment 1101 that would stop the transfer of the MC-12W ISR aircraft from the Air Force to the Army. And I think it's something that is pretty significant. We're talking about the reconnaissance, intelligence and reconnaissance, and the MC-12W is a King Air or a C-12, and it's one that apparently right now it's in the custody or under the jurisdiction of the Air Force, and this bill would change it from the Air Force to the Army. Well, neither the Air Force nor the Army wants to make that change, and there ought to be a way to support that. There are several other amendments that will be coming forward that will be offered. One I feel very strongly about is the sale of the F-16 C and D models to Taiwan. And then lastly, I feel very strongly about this. Back in 2007, we changed the commands to create AFRICOM. AFRICOM prior to this time was a part of three commands: Central Command, Pacific Command, and European Command. Well, it's such a significant in terms of national security, in terms of our economy, and the activity that's going on right now. For example, ever since 9/11, we've been working with the Africans to help develop in Africa our programs, our 1206 programs, our train and equip programs, and more recently we're involved in the LRA issue in 4 countries in Africa. Well, there is an effort now to, I think almost any member, I guess I'd feel the same way, to take that command. It's now in Stuttgart, Germany, and put it in Texas or Florida or someplace in the United States. And I think that would be something that would inure to the benefit maybe of a member, a senator, but on the other hand, it creates certain problems. When the African Command came into effect, and I think that's one of the few issues that I probably am more familiar with than most other members are, the obvious place would have been to have that command located in Africa itself. And my choice at that time was Ethiopia. And I think there's a lot of justification for that. But they said because of the political problem, if you go back historically in Africa and you look at the colonialism, there is this thing embedded back in the minds of people in Africa thinking that having a command, a United States command located in Africa might revert back to some of the colonial days. And that's the effort that's the concern that people had. So anyway, I thought it would have been better to have it in Africa itself, but because of this, and by the way, I've talked to many of the presidents of countries over there, President Kikwete in Tanzania, and President Kagame in Rwanda, President Kabila in Congo, and several of the others. They say, yeah, you're right, it would serve better to have that command located somewhere in Africa, but we have the political problem with the people who would think that's a move back toward colonialism. So it's a complicated problem. However, I do believe that all of the generals pretty much feel that AFRICOM should remain where it is. At least Stuttgart is in the same time zone. It's easier to transport people and equipment back and forth, and so I would support defeating any of the amendments that would change that situation. With that, Mr. President, I'll yield the floor and suggest the absence of a quorum.
The clerk will call the roll.
Mr. Akaka.
quorum call.
I ask unanimous consent to initiate the quorum call.
Without objection.
And unanimous consent to speak as if in morning business.
Without objection.
Thank you, Mr. President. Last week we celebrated Thanksgiving, the time of year when we look back and we give thanks for our blessings. We're all grateful for our family, our men and women in uniform, and those who also defend our nation in civilian life. I'm particularly thankful this year because 1 year ago today, I had the honor of my life to be sworn in as the newest junior senator for the state of Illinois to complete Senator Obama's term. And what a year it's been. Coming from the House of Representatives, I had to adjust to the measured place and pace of the Senate. While Americans may have a dim view of what we do here, I remain an optimist. Americans have always faced tough challenges, but then rose to the occasion more successfully than any other people in history. While I believe there is much more to do to reduce debt, repeal burdensome regulations, and encourage job creation, I want to take a few minutes to lay out what my team has accomplished for the state of Illinois and the nation in 1 year. In my first 30 days in office, we moved 3 times, we hired a staff, and then voted to prevent the largest tax increase in history, while Congress extended tax relief for millions of Americans in that legislation. We also worked to block the transfer of al-Qaeda terrorists from Guantanamo Bay to northwestern Illinois. Since then, Congress enacted the Budget Control Act, mandating about $2 trillion in reduced federal borrowing over the next 10 years, which, in my view, is only a first step in addressing Washington's out-of-control spending. No one here would say that we have come near to solving the problem, but I am heartened by the bipartisan and bicameral support of the Gang of Six proposal, and now with the probable support of 45 Republican and Democratic senators, I hope we will soon go big with their recommendations to find $4 trillion in savings. The Congress approved 3 free trade agreements to boost U.S. exports to South Korea, to Colombia, and Panama, as both President Obama and Speaker Boehner wanted. The action will open up markets for Illinois farmers and boost exports from companies and employers like John Deere in Moline, Caterpillar in Peoria, ADM in Decatur, and Navistar in suburban Warrenville. Congress repealed the onerous requirement mandated by the health care law that required small businesses to document all payments over a few $100s. This absurd 1099 rule was the first part of the health care law to be repealed, and it will soon be followed by the misnamed Class Act that even the Obama administration appears to have canceled by executive action. Additionally, Congress reformed our patent system by moving to a first-to-file instead of a first-to-invent system. This signals to inventors that they should quickly file their inventions and allows us to innovate without endless and expensive litigation. Along with that effort, the Kirk Amendment authorizing the Patent Office to have a small business fast lane became law. My office published a Great Lakes report card that gave our largest body of fresh water a C grade to draw attention to invasive species, to poor water quality, and beach closures, demonstrating the need for our legislation by myself and Senator Durbin to ban sewage dumping in the Great Lakes. To create more construction jobs in Illinois, I introduced the Lincoln Legacy Infrastructure Development Act, which would unlock more than $100 billion in new revenue for roads, rail, transit, and airports through more infrastructure funded by public-private partnerships. And I've since met with Secretary LaHood, Chief of Staff Daley, and House Chairman Mica as a way to advance this legislation to restart our economy. We've also had an active year in protecting our allies and America's interests overseas. On the floor today, we may consider the Menendez-Kirk Amendment, pending the Defense Authorization Act, which would impose crippling sanctions on the Central Bank of Iran. This is a result of a collaborative effort involving 92 senators who signed the Schumer-Kirk letter calling for the U.S. to collapse Iran's terror-sponsoring bank. In May, Senator Gillibrand and I introduced the Iran Human Rights and Democracy Promotion Act, which establishes a special representative on human rights and democracy in Iran, imposing sanctions on companies that sell or service products that enable the Iranian regime to oppress its people. It would require a comprehensive strategy to promote Internet freedom in Iran and reauthorize the Iran Freedom Support Act. The bill is now part of the Iran, Syria, and North Korea Sanctions Consolidation Act. In February, the Senate passed a Kirk resolution condemning human rights abuses in Iran, and we founded the Iranian Dissident Awareness Program to make dissidents like Hussein Renagi Maleki, a blogger and human rights activist, and Nasrin Sotoudeh, a lawyer and human rights activist, household names now in America. We also fought for strict assurances that data collected from our new X-band radar in Turkey would be shared with our allies in Israel. In total, my office introduced 18 bills and resolutions and 11 amendments. We co-sponsored 132 pieces of legislation. Also, I'm a member of 4 committees that have held more than 130 hearings and markups. This year, we worked on the reform of No Child Left Behind, and those reforms passed the committee with bipartisan support. We also worked on legislation regarding flood insurance and funding bills under the Appropriations Committee. Now, most Americans who watch cable news think that all Democrats and all Republicans may hate each other. While Congress has grown more partisan, I'm particularly proud of the bipartisan partnerships that we've fostered in such a short time. I have continued a long-standing battle against the corrupt sugar program by working with Senator Shaheen of New Hampshire on S-25, the Stop Unfair Giveaways and Restrictions Act, the Sugar Act of 2011, which would eliminate sugar price supports and increase costs for consumers that destroy American manufacturing jobs. Senator Wyden and I introduced legislation targeting more than $60 billion in Medicare fraud every year by issuing new identity theft-proof medical ID cards, offering the same ID card protection that our troops have for our seniors. I also joined Senator Wyden on his effort to ensure your constitutional rights are protected with regard to your GPS data and cell phone and other location information. Senator Casey and I worked together on anti-bullying legislation to keep our kids safe at school, and I joined Senator Whitehouse in an effort to criminalize the pointing of lasers against civil aircraft to keep that industry safe. In my capacity as the top Republican member of the Military Construction and Veterans Affairs Appropriations Committee, we worked across the aisle with Chairman Tim Johnson to pass the first standalone appropriations bill out of the Senate since 2009. And since then, we broke the logjam on appropriations bills, and I hope to quickly complete that legislation. I'd especially like to recognize one of my best friends in the Senate, Senator Joe Manchin of West Virginia, for our collaborative effort on many issues, the latest being a bipartisan resolution calling for the Congress to go big on deficit reduction. When we first came to the Senate together, we saw that there were few opportunities for Republicans and Democrats to interact outside the Senate floor. It's why we began to have an open lunch together each Thursday instead of the regularly scheduled partisan lunches to discuss ways to bridge the political divide in the Senate and in Washington. I'd also like to highlight the partnership that I've developed with my senior senator from the state of Illinois. While we may not see eye to eye on many issues, Senator Durbin and I have worked closely on a whole host of issues for Illinois. Following in the footsteps of the late Senator Paul Simon, Senator Durbin and I have now held more than 25 joint constituent coffees here in Washington. It's like a town hall meeting where we talk with Illinois families about what is going on at home and in the Congress. In March, Senator Durbin and I worked with Secretary of Transportation Ray LaHood to help the City of Chicago, American, and United Airlines to come to agreement to keep the O'Hare modernization program moving forward. This is the single greatest job creation program in northern Illinois, and the agreement that we helped foster keeps thousands at work at O'Hare. We've worked closely to bring high-speed rail to the state of Illinois and together introduced legislation to expand charter schools, to improve access to EpiPens at schools, for children with severe allergies and to ensure military families in North Chicago continue to receive their federal education assistance. We fought to open a new federal prison in Thompson, Illinois, but without al-Qaeda detainees, to create jobs in northwestern Illinois and address also flooding issues in southern Illinois and levee rehabilitation in the Metro East area. We have also successfully confirmed 4 new judges for central and northern Illinois and have an additional 2 nominations, 1 Democrat, 1 Republican, pending. But legislation is not all that we do here. In my opinion, one of the most important things a member of Congress can focus on is constituent service. We formed advisory boards for African Americans, Latinos, small business, agriculture, health care, education, and students. Since I first came to the House of Representatives in 2001, I worked diligently as an advocate for Illinois before the federal government. In 1 year now, my staff has held more than 3,440 meetings with constituents and other officials and dignitaries. To be as accessible as possible, I have visited 50 out of Illinois' 102 counties and held 20 town hall meetings throughout the state. This month, my successor in the House of Representatives, Congressman Bob Dole, and I held the first ever live Facebook town hall meeting and answered questions we received via the social networking site and Twitter. My office has arranged 340 Capitol and White House tours for approximately 2,800 constituents. We received more than 85,000 phone calls and responded to 66,000 letters and emails. We've helped more than 4,000 constituents with casework details before the government and written more than 200 letters in support of Illinois towns, counties, and organizations for federal grants. I've convened 8 constituent advisory boards and met a total of 18 times. My office helped process 122 passports and assisted 750 veterans in their concerns before the VA. We've accomplished quite a bit this year, and I remain optimistic about the long-term future of our nation. We can out-innovate and out-produce any nation on the planet if we create an environment that supports full job creation. But there's still a lot of work to do. The Illinois unemployment rate stands at over 10%, and it seems like each day we hear of a new company thinking of leaving our state. The health care law threatens to further drag on our economy, and we face a global sovereign debt crisis in Europe and fears of future credit devaluations for the United States. U.S. troops continue to pursue enemies of freedom in Afghanistan and Iraq, and Iran continues its effort to develop nuclear weapons. Protests are accelerating in Egypt, civil unrest in Syria, and piracy remains a concern off the coast of Somalia. Just as I have for the past year, I will spend the next 5 years making sure that America remains the best place on earth for any individual to rise to their full potential, a place where your rights are protected against the government, whose main mission should be to defend us and to foster higher incomes for our families. In these battles, I will advance the interests of the state of Illinois as the job engine at the center of the North American economy, the protector of the Lake Michigan and Mississippi ecosystems, and the special place that said Abraham Lincoln, and hopefully future Lincolns, for national leadership when America needs it most. Of course, my heart and soul will always be with the troops, their care, their mission, their spirit of defending a place that is the greatest force for human freedom and dignity ever designed. I'm truly grateful for the opportunity to serve my nation twice, in the Navy and in the Senate. I thank the people of Illinois for the first year in the Senate and for the even bigger things that we will do together over the years to come. And with that, Mr. President, I yield back and would suggest the absence of a quorum.
Clerk will call the roll.
Mr. Akaka.
Yes, I would ask that the quorum be vitiated.
Without objection.
Thank you, Mr. President. I have offered two amendments. I have filed two amendments I'd like to offer at some time, but I'd like to talk to them now. I am strongly opposed to the detention provisions in the defense bill before us, and I'm disappointed that Senator Udall's amendment did not pass. Taken together, sections 1031 and 1032 would fundamentally alter how we investigate, arrest, and detain individuals suspected of terrorism. When I say Senator Udall, I mean the other Senator Udall, Mr. President. Before I get into the details of why I oppose these detainee provisions, I think it's important to recognize that September 11th irrevocably and unalterably changed our lives. I was in Minnesota that terrible day. A number of Minnesotans died in the towers, in the air, and at the Pentagon. In New York, in the months following the attacks, I attended the funerals of brave firefighters and law enforcement officers who sacrificed their lives to help rescue folks from the towers. I can't shake those images from my mind, and I'm guessing, like many of you, I won't ever be able to erase the horrors of September 11th from my mind. September 11th reminded us that we are vulnerable and that we are fighting an unusual enemy. It forced us to reassess our approach to counterterrorism, and it forced us to redouble our efforts to track down people aimed to do us harm. But it is exactly in these difficult moments, in these periods of war, when our country is under attack, when we must be doubly vigilant about protecting what makes us Americans. The founders who crafted our Constitution and Bill of Rights were careful to draft a Constitution of limited powers, one that would protect Americans' freedom and liberty at all times, both in war and in peace. Today, as we contemplate fundamentally altering the criminal justice system our founders developed in order to create a military detention system, a system that would permit the indefinite detention of U.S. citizens and lawful residents of the United States for acts committed here in the United States. I think it is important to pause and remember some of the mistakes that this country has made when we have been fearful of enemy attack. Most notably, we made a grave and indefensible mistake during World War II when President Roosevelt ordered the incarceration of more than 110,000 people of Japanese origin, as well as approximately 11,000 German Americans and 3,000 Italian Americans. There is a memorial right across the street from the Capitol that should remind us all of this terrible mistake. In 1971, President Richard Nixon signed into law the Non-Detention Act to make sure that the U.S. government would never subject any Americans to the unnecessary and unjustifiable imprisonment that so many Japanese Americans, German Americans, and Italian Americans had to endure. It wasn't until 1988, 46 years after the internment, that President Reagan signed the Civil Liberties Act, that the government formally acknowledged and apologized for grave injustice, the grave injustice that was done to citizens and permanent residents of Japanese ancestry. These were dark periods in American history, and it is easy standing here today to think that that is all behind us, that it is a distant memory. But I fear the detention provisions in this bill forget the lessons we learned from the mistakes we made when we interned thousands of innocent Japanese, Germans, and Italians, or when we destroyed the lives of supposed communist sympathizers with nary a shred of evidence of guilt. In the weeks following September 11th, the Justice Department made extraordinary use of its powers to arrest and detain individuals. We arrested hundreds of people for alleged immigration violations and dozens more under a material witness statute. None of these individuals were charged with a crime. And all of this happened without the military detention scheme envisioned in this bill. This was also a mistake and one that should not be repeated. But if we pass the defense authorization with Section 1031, Congress will, according to the arguments that were made on the floor last week, for the first time in 60 years, authorize the indefinite detention of U.S. citizens without trial, without charge, and without trial. This would be the first time that Congress has deviated from President Nixon's Non-Detention Act, and what we're talking about here is that Americans could be subjected to life imprisonment. Think about that for just a moment. Life imprisonment without ever being charged or tried or convicted of a crime, without ever having an opportunity to prove your innocence to a judge or a jury of your peers, and without the government ever having to prove your guilt beyond a reasonable doubt. Life in prison. I think that denigrates the very foundation of this country. It denigrates the Bill of Rights. It denigrates what our founders intended when they created a civilian, non-military justice system for trying and punishing people for crimes committed on U.S. soil. Our founders were fearful of the military, and they purposely created a system of checks and balances to ensure that we did not become a country under military rule. And if this bill passes, the Supreme Court should find these detention provisions unconstitutional. But let's put that aside for now and focus on what we are currently doing right to fight terrorism, because we are doing a heck of a lot of great things when it comes to our national security. I think we actually need to remember that. And we need to remember that we are winning the fight against terrorists without trampling on our constitutional rights. Just last May, under the tremendous leadership of President Obama and Secretary Panetta, then head of the CIA, we hunted down and killed Osama bin Laden. A few days ago, the Washington Post reported that the Al-Qaeda core has contracted and weakened since then, and its leadership ranks have been reduced to 2 members. To be sure, that does not mean that Al-Qaeda is no longer a threat, particularly coming from groups outside of its core, but it's a remarkable achievement nevertheless. Our current counterterrorism strategy is not broken. Indeed, just the opposite is true. We are winning the war against Al-Qaeda. There is no indication, none, that we need to fundamentally alter our approach to locating terrorists here or overseas. Under Director Mueller's leadership, the FBI has turned itself inside out, and over the last 10 years since September 11th, it has become an intelligence-gathering counterterrorism machine. I can't say that I have always agreed 100% with 100% of the FBI's tactics, and there are times when I worry that they may be overstepping. But make no mistake, if our goal is hunting down the bad guys, the FBI knows what they're doing. There is no reason to think we need to change course and create an entirely new system that would completely supplant the resources and expertise of the FBI. For those who would argue that we need to shift these people out of our civilian criminal justice system and away from Article III courts and into a military system, I just have to ask, why? Where is the sign that we have a problem that needs fixing? There is no reason to think we need to create an entirely different framework for a problem we have been dealing with for centuries. This enemy is not so different that we need to upend our criminal justice system. Mr. President, I think this is a solution in search of a problem. There is no need to go down this path. We should be focused on doing what is best for this nation and what is best for protecting Americans. We should be working together on this, not coming up with additional ways to divide and polarize this country. That's why when the Secretary of Defense, the Director of National Intelligence, and the Director of the FBI expressed serious concerns about these provisions, and when the President's top counterterrorism advisor, John Brennan, complains that these provisions will make it even harder for them to locate and detain terrorists in the United States and overseas, we should probably listen to them. Section 1031 runs the risk of authorizing the indefinite detention without trial of Americans. Section 1032 is unnecessary and complicates our counterterrorism policy. They're bad policy. In short, these provisions should not be passed. They are not well-considered counterterrorism policy, and they would authorize poorly understood and deeply troubling policies. That's why I put forward amendments that would strike each of these two sections. That's why I co-sponsored Senator Mark Udall's amendment, the presiding officer's cousin. That's why I co-sponsored his amendment and be happy to co-sponsor amendments from the presiding officer as well. But that's why I sponsored his Mark Udall's amendment that would have sent these matters back to the administration and the relevant committees of Congress for the full consideration, discussion, and the debate that they deserve. Our national security and our freedom require nothing less. Mr. President, I thank you, and I yield the floor and would suggest the absence of a quorum.
The clerk will call the roll.
Mr. Akaka. Mr. Alexander.
understand the procedure right now.
The Senate is currently in a quorum call.
I ask that the quorum call be vitiated.
Without objection.
If I understand the procedure, it is appropriate for me to speak. I will not call up my two amendments, but I'd like to take the opportunity to speak about them at this time. I trust that's in order.
Senator is recognized.
Thank you very much. Mr. President, I rise to express my continued opposition to the detention provisions in the Defense Authorization Bill. Mr. President, I was on the Intelligence Committee prior to 9/11, and I've watched the transition since that time. And I've watched America, to use a phrase, get its act together. And I am very proud of where this country stands at this time, with the procedures, the interrogation techniques, the custody issues, and the prosecution issues that have been worked out in the last 10 years. In my judgment, this country is safer than we have ever been before. Before the recess, I laid out my views on why these provisions were detrimental to national security, because they reduce the President's flexibility to make decisions how best to detain and potentially interrogate and prosecute suspected terrorists. So today I'd like to speak to the two amendments I have filed, and I'll describe them in a moment. Let me also put in the record two letters in opposition to the detention provisions in the underlying bill. One written to me from the Director of National Intelligence, James Clapper. The second written yesterday to Chairman Levin from Bob Mueller, the Director of the FBI. These letters are in addition to the Statement of Administration Policy, which includes a veto threat to the detention provisions, and the letter from the Secretary of Defense, Leon Panetta, both of which are already in the record. So I note, Mr. President, that the provisions in the bill we are considering are opposed by the White House, by the Secretary of Defense, the Director of National Intelligence, and the Director of the FBI. These top national security officials are all concerned that the bill reduces the administration's flexibility to combat terrorism, both at home and abroad, and I would agree with that. I will ask at the appropriate time for a vote on amendment number 1125, which will limit mandatory military custody to terrorists captured outside the United States. This is a very simple amendment that only adds one word, and that one word is abroad to Section 1032 of the underlying bill. Currently, this bill creates a presumption that members or parts of al-Qaeda or associated forces will be held in the military detention system. And I disagree with that approach. I believe that the President should have the flexibility to hold captured terrorists in the military or the criminal justice systems. And the decision of which system to use should be made on individual facts and evidence in each case. Putting aside that general view, I am very concerned that creating a presumption for military custody, which this bill does, and requiring a cumbersome waiver process will jeopardize counterterrorism cases and intelligence gathering. This concern is not only mine. It has been raised by the White House, by Secretary Panetta, and very directly by Director Mueller. So my amendment would clarify the situation and refuse the confusion and delay that this bill, I believe, will cause. My amendment will make clear that under Section 1032 of this bill, the United States Armed Forces are only required to hold a suspected terrorist in military custody when that individual is captured abroad. All that amendment does is add that one word, abroad, to make clear that the military will not be roaming our streets or looking for suspected terrorists. My amendment does not remove the President's ability to use the option of military detention or prosecution inside the United States. The amendment makes clear that inside the United States there is no presumption for military custody. Inside the United States, a customs agent or local law enforcement officer could follow his or her standard process and turn a suspected terrorist over to the FBI for handling without having to worry about whether a waiver may apply or whether it is required. The FBI has changed. There are 56 field offices, there is a national security branch, and it is staffed with 10,000 people inside the United States. The FBI is well equipped to handle a terrorist inside the United States. Listen to what Director Mueller wrote. He notes, and I quote, "The legislation introduces a substantial element of uncertainty as to what procedures are to be followed at perhaps the most critical time in the development of an investigation." Now, I understand that the chairman and ranking member of the Armed Services Committee have included a waiver and have required that the administration issue procedures to lay out how the mandatory military custody provision will be carried out. But the administration is telling us with a unanimous voice from all its senior counterterrorism officials that this provision is harmful and unnecessary. But we say we know better. I don't believe we do know better. And I think not to listen to those who are really responsible to carry out these missions in what is a very difficult field today based on a careful assessment of intelligence is really a mistake. The administration has threatened to veto this bill and said, and I quote, "It strongly objects to the military custody provision of Section 1032, end quote, in its official statement of administration policy, because it would, and I quote, tie the hands of our intelligence and law enforcement professionals, end quote. So here are the experts saying don't do this. It will tie our hands. And here's the political branch saying we know better. Now, if something had gone wrong, if there had been mistakes, if there hadn't been 300 cases tried successfully in civilian federal courts and 6 cases and a muffed history of military prosecution in these cases, I might agree. But the march is on. Militarize this thing from stem to stern. And I really disagree with that. You know, when something isn't broke, don't fix it. And now there are rapid reaction forces in terms of the Hig numbers who can go to an event, who can rapidly take over a suspect, who can carry out proper and effective interrogation, and the administration has an opportunity to decide, well, the facts and the evidence really best suited for a civil federal prosecution, or the facts and the evidence really best suited for a military commission. That's what we're taking away from the administration. It was well practiced during the Bush presidency, and it has been well practiced by the Obama presidency, and virtually every professional organization connected to the handling of terrorists and the intelligence thereof says to change it is a mistake. So, the amendment I'm offering, limiting mandatory military custody to detainees outside the United States, is, I believe, a major improvement in the underlying bill. It removes the uncertainty that will occur if military custody is required for detainees captured inside the United States. Frankly, I would prefer that the provision be struck in its entirety, as I don't believe we should be creating a presumption of military custody over the law enforcement route. That's not what this country is about. You know, there's posse comitatus. The military aren't supposed to be doing these things. But if there's going to be a provision, it should at least do no harm to our ability to detain, to interrogate, and prosecute terrorists. So I ask for my colleagues' support on this amendment. While I'm on the floor, Mr. President, I'd like to speak briefly to the second amendment I have filed, and which I also seek a vote since the Udall amendment has failed. That is amendment number 1126, which would prohibit United States citizens from being held in indefinite detention without trial or charge. As members know, Section 1031 of the underlying bill updates and restates the authorization for the use of military force that was passed on September 18, 2001, 10 years ago, 1 week after the attacks of 9/11. The provision updates the authority to detain terrorists who seek to harm the United States, an authority that I believe is consistent with the laws of armed conflict. However, I strongly believe that the United States government should not have the ability to lock away its citizens for years and perhaps decades without charging them and providing a heightened level of due process. We don't pick up citizens, we don't incarcerate them for 10 or 15 or 20 years or until hostilities end, and no one knows when they will end, without giving them due process of law. So my amendment simply adds the following language to Section 1031 of the underlying bill. We would add this language: the authority described in this section for the armed forces of the United States to detain a person does not include the authority to detain a citizen of the United States without trial until the end of hostilities. It's hard for me to understand any member of this body that knows and respects the Constitution wouldn't vote for this. Because without this amendment, Congress is essentially authorizing the indefinite imprisonment of American citizens without charge or trial. As I said on the floor earlier, 40 years ago, Congress passed the Non-Detention Act of 1971 that expressed the will of Congress and the President of America that America would never repeat the Japanese-American internment experience, something that I witnessed as a child, close up and personal, and would never subject any other American to indefinite detention without charge or trial. In the 40 years since President Richard Nixon signed the Non-Detention Act into law, Congress has never made an exception to it. Now, the issue here in this bill is the Congress making an exception that has never been made before by the Congress. And what we are saying is it is okay to detain an American citizen without trial ad infinitum. I don't think it is. I don't think that's what our Constitution is all about. The provision in this bill threatens to do just that. And so I ask unanimous consent to enter into the record a column published yesterday in the San Jose Mercury News of California from Floyd Mori. Matter of fact, I know Mr. Mori well. He is the National Executive Director of the Japanese American Citizens League, which is the oldest and largest Asian American civil rights organization in the United States. The Japanese American Citizens League, or JACL as we would say, has been an active voice on the wrongful internment of Japanese Americans during World War II. And I believe it's worth listening to what they have observed from that painful history. The administration has threatened to veto this bill and said the following in its official statement of policy, and I quote, "After a decade of settled jurisprudence on detention authority, Congress must be careful not to open a whole series of legal questions that will distract from our efforts to protect this country," end quote. Yet, by allowing the military to detain United States citizens indefinitely, Congress would be opening a great number of serious legal questions, in my judgment. This amendment would restore the language that was in an earlier version of this bill that would have established a similar ban on the indefinite detention of U.S. citizens. It is also consistent with the way we've conducted the war on terror in the past 10 years. In cases where the United States has detained American citizens, including John Walker Lynn and Jose Padilla, they have eventually been transitioned from indefinite detention to the criminal justice system, and both have been convicted and are serving long prison sentences. John Walker Lynn pled guilty to terrorism charges and was given a 20-year sentence. And Jose Padilla was convicted of terrorism conspiracy and sentenced to a 17-year prison sentence. So I believe this amendment is consistent with past practice and with traditional United States values of due process. We are not a nation that locks up its citizens without charge, prosecution, and conviction. My amendment reflects that view. I believe in that view, and I hope this body does as well. So I urge its adoption. Mr. President, in conclusion, I ask my colleagues' support on these amendments because I believe they will improve the legislation. I yield the floor. I note the absence of a quorum.
The Secretary will call the roll.